Good afternoon, all, and my video today, as promised in my last video, is on the topic of law school doesn't cure autism. So let's get into it. First of all, what I want to say is that autistic people do get higher education and do go to law school. Now, if you've seen one person with autism, you've only seen one person with autism, and all autistic people are different. It's a spectrum, and we all have different strengths and different disabilities within the autism spectrum. However, there are autistic people who have in the past and are today enrolled in law school. And so autistic people do get dragged into the courts. Autistic people do have to file lawsuits to vindicate their rights or to try to get access in multiple walks of our lives. And autistic people are commonly advised by all sorts of disability rights organizations, autism organizations, friends, other lawyers, and even deputy sheriffs that sometimes we have to go to the court and sue over something that is impacting us as an autistic individual. So when that happens, autistic people, and there is research on this, for each autistic person, the lifetime cost of autism to the autistic person and their family is around $3.2 million over the lifetime. And the most recent study on this that I have found also points out that the average autism family income is $61,000 a year or under. So autistic people and autism families, almost all of us, cannot afford to hire a lawyer or pay a lawyer to represent us if we get dragged into a court or forced into a court to sue for one reason or another, because of the enormous $3.2 million lifetime cost of autism and the almost total absence of autism financial supports and services in the United States and in the state of Florida, where I now live in particular. And so when an autistic person goes into a court and has to sue, these disability rights organizations, autism organizations, even sheriff deputies will tell the autistic person, don't worry, the court will help you. Okay? So far, it sounds okay. It sounds maybe not too scary. And the typical rule for pro se people who have to go in and sue and represent themselves or get dragged into the court and have to represent themselves pro se is what they call the rule of leniency. How However, if the autistic person has, by happenstance, ever enrolled in a law school, higher education program, then lawyers and courts have created this law school graduate stereotype. Now, this law school graduate stereotype is a shorthand way of the neurotypical judges and lawyers communicating amongst themselves that, well, this person says they have an autism diagnosis, but he or she is a law school graduate. And therefore, we can disregard their autism diagnosis and the fact they are autistic, which is an implicit way of saying law school cures autism, because there is no other meaning that you can derive. Now, what is a stereotype? A stereotype is a fixed or generalized mental picture that neurotypical lawyers and judges have of a group, often involving an oversimplified opinion or prejudiced judgment. It's a shorthand way of thinking about people based on their group membership rather than as individuals. A more detailed explanation is, stereotypes are generalizations about a group, often based on limited information or characteristics. They tend to simplify complex realities and don't account for individualized differences within a group. Stereotypes can be positive or negative, but they often reflect prejudice and can contribute to discrimination. They serve as cognitive shortcuts, allowing people to quickly process information and make snap judgments about individuals based on their group affiliation. Stereotypes can have harmful consequences, shaping expectations, impacting interactions, and perpetuating inequalities. And so now I want to talk about how lawyers and judges have created and formed the law school graduate stereotype. So, one of the things that a person will learn if they go to law school is that, especially if you're autistic, is that almost everyone around you is neurotypical. There are very few autistic people enrolled in law schools. And, well, let's just talk about the Florida bar, for example, since I live in Florida. What are the odds that an autistic law school graduate can obtain an attorney license and become a Florida bar member? Well, it is around 1 in 111,000. So you might call that a real long shot. So, how do these neurotypical law school graduates who become licensed bar members, lawyers, and judges, how do they create this law school graduate stereotype? Well, To begin with, most of them are neurotypical. So they can easily and automatically fit in to a neurotypical designed world and float in and out of neurotypical social circles and easily and readily meet neurotypical social expectations and norms and standards. And so the vast majority of them, when they apply for bar admission and they fill out the bar admission application and then it's reviewed by the bar examiners, they just slip right through and they take and pass the bar exam. So basically all they do is they fill out the application, they take and pass the bar exam, and just like that, they are admitted to the bar. They never encounter any snags in their bar admission process because they're neurotypical. And so the vast majority of them do not have any awareness of, besides those couple things, what a bar examiner does. What does the Florida Board of Bar Examiners do? What are the kinds of things they do? And is there more to it than just filling out the bar application, passing the bar exam, and just like that to get your attorney license with no scrutiny? Well, yeah, they do a lot of things. So one of the things the Florida Board of Bar Examiners does is, and I'll show you. This is an AI overview, and I'm not just going to say this. Y'all can get it right from the internet. The Florida Board of Bar Examiners, FBBE, provides special accommodations for applicants with disabilities who require them to take the Florida Bar examination. These accommodations are intended to ensure that qualified applicants with disabilities can take the exam under conditions that are equivalent to those of other candidates. Okay, so that, in terms of the evidence code, would be called a declaration against interest. So it's an admission that is so commonly known it could be taken judicial notice of by any judge that a law school graduate, a bar exam passer, and a bar member is not an ableism stereotype. In other words, when you use the phrase is a law school graduate, or passed a bar exam, or is a licensed bar member, those words do not stand for not disabled. That's ableism. But in this law school graduate stereotype that lawyers and courts have created, the almost 100% homogeneously neurotypical bar and bench, particularly in Florida, the stereotype of law school graduate is ableist. It is ableism alive, kicking and well, and the stereotype is one of ableism. The portrayal of this generalized law school graduate is one of a person who does not have any disability. So, as I said, the thing about a stereotype is it's oversimplified. And so when lawyers and judges use the phrase is a law school graduate or is or was a licensed bar member, it has a specific ableist stereotypical meaning. The definition, the meaning of that phrase is a not disabled law school graduate. So, because lawyers and judges have created this ableist law school graduate stereotype, when an autistic person like myself either gets dragged into a court or is forced to have to go into a court and sue, and happened by happenstance to have enrolled in a law school, then when the court is trying to assess whether that autistic person is appropriately masking so that they fit in and they're indistinguishable from a neurotypical so they don't upset or inconvenience or disrupt the court and the neurotypical expectations and the neurotypical designed court environment, instead of the rule of leniency that all others get, the lawyers and judges will start saying, this autistic person is a law school graduate. Those are red flag cue words, issue spotting words, a type of neurotypical code speak between the neurotypical opposing lawyer and the judges that conveys to the judge that everybody knows that when we say the phrase is a law school graduate or is or was a licensed bar member, that that person has no excuse to deviate from the neurotypical norm and fail to fit in. So then what happens? I'll give you an example, an actual example of this bar member lawyer code speak, ableist stereotype. And so this is an actual motion filed in an actual federal court in the Northern District of Florida, Gainesville Division. And this is defendant Carl Schweit's motion to dismiss counts 1, 3, and 4 with incorporated memorandum of law. Now, who is Carl Schweit? Well, he's a licensed Florida bar member. And he was the co-chair of the Florida Bar's Disciplinary Committee. And he filed this motion through his counsel, who's another Florida Bar member lawyer named Trevor Rhodes, Esquire. He worked for the law firm Banker, Lopez, and Gassler, PA. And in this motion, once as an autistic person, I was forced to go into the court and sue after being advised by another Florida Bar member, Tom Carey of Carey and Leisure, PA, that I had a valid and meritorious claim for being rear-ended in a car accident and suffering personal injuries and needing to have medical treatment, when I was forced into the court to sue because the Florida Bar basically has admitted it does not require any mandatory specific autism training of any bar members or lawyers in Florida. When I went into the court to sue, And Mr. Schwait and Mr. Rhodes, who are lawyers, neurotypical lawyers, were confronted with an autistic person who they investigated and found out was a law school graduate and passed the California bar exam. They immediately trotted down the boilerplate path of the ableism law school graduate stereotype. And here's what that looks like. I'll read this verbatim. Typically pro se plaintiffs, such as those at hand, are held to a less demanding pleading standard than a lawyer. Furthermore, and here it comes, plaintiffs themselves have set forth in the complaint that they have law degrees, with David Petrano having passed the bar in Florida and Mary Catherine Day Petrano having passed California's bar. So that's the neurotypical lawyer and judge shared ableist stereotype is a law school graduate or has passed a bar exam or is or was a licensed lawyer, ableist neurotypical code speak stereotype. And now I'm going to give you the judges parroting that same ableist stereotype back to the neurotypical lawyers who code speak the special law school graduate ableist stereotype of not a disabled person. And I'll read this too. And this is from a transcript of a hearing in the United States District Court in Tampa, Florida, and the Honorable James D. Whittemore, District Judge. So, being autistic, I had made several requests which were disregarded and ignored for the autism accommodations I needed to be able to effectively communicate and fully and equally participate in my court case that was assigned to him. And let's see what he said and what his rendition of the law school graduate ableist stereotype of not disabled sounds like. Any pro se pleading is to be and has been accorded leniency. And then addressing myself and my husband, you do not fall into that traditional description of a pro se litigant. Here it comes. You are both educated in the law and procedure. One of you is licensed to practice law in this state. That was my husband. One of you is optimistic of becoming licensed to practice law in this state. But you both have the legal education that is the beginning point of conducting yourself as an officer of the court. So you're not your traditional pro se plaintiffs. You are much more than that. And that's what makes this whole case so troublesome. Unlike a pro se litigant who is not educated in the law, who makes mistakes, blunders, and haplessly tries to present their case, you have used or attempted to use your knowledge to burden not only the court, but the defense and this process. Now, the thing about this ableism stereotype is that because it is an ableism stereotype of a not disabled law school graduate when a disabled law school graduate who actually got special accommodations by their bar examiners comes to a court and tells the lawyer and the judge that I need accommodations. I'm autistic. I need accommodations. It is inescapably, in almost every instance, viewed as a burden on the courts, because then the courts have to do something to accommodate the disability. And if the disability, like autism, with delayed processing, requires extra time, oh, that's seen as a huge burden on the opposing lawyer and the court. And that's part of the ableism stereotype, is a law school graduate. And so the Honorable Judge Whittemore, continuing with the details of this ableism stereotype, stated, "This case is not about accommodations for disabilities. Yet, Mrs. De Petrano insists on making it the focus of every argument she makes." Now, it's very common knowledge in the autism and autistic community that autistic adults are told that we have to advocate for ourselves, that we have to know what our functional limitations are, and that we have to ask for accommodations. So we're being advised on the one hand by all of these disability rights organizations and autism organizations, and even other bar members who have responsibly taken a Title II Americans with Disabilities Act CLE course, that we have to ask for accommodations. And if we're ignored, to ask again. And on the other hand, there's this mismatch because the neurotypical lawyers and judges have created this ableist law school graduate stereotype that is a stereotype that's simplified to picture in their mind, to portray in their mind that the big picture of law school graduate is a not disabled person. So when I tried to explain to the Honorable Judge Whittemore that I'm autistic, I'm disabled, and I took and passed the California bar examination with special accommodations, and this shouldn't have been any surprise because the Florida Board of Bar Examiners has a whole page, which I've already discussed in this video, about individuals with disabilities can ask for special accommodations on the Florida bar exam to take and pass the Florida bar exam and be admitted as members, lawyers of the Florida bar. So the Honorable Judge Whittemore then concludes his ableist law school graduate stereotype. You are trying to obey. You're doing the best you can. I can't accept that because it's obvious from this record you have not done the best you can, and you are not trying to obey. You continue to this day rationalizing, justifying, and complaining. Okay. Now that is one judge iteration of the ableist law school graduate, not disabled stereotype. I'll give you another. This one is entered in the 8th Judicial Circuit of Florida in a case, an order on motions to dismiss by the Honorable Judge Monica Brasington. And here again, we see the judge starting to trot down the path of this ableist law school graduate stereotype of not disabled. Both plaintiffs have also indicated to the court through pleadings or other representations that they have completed law school. And in a companion order, in this case, the same circuit judge, Honorable Monica Brasington, also trotted down the path of the ableist law school graduate stereotype. And here we see the same thing. The plaintiff also indicated to the court that she successfully graduated from law school. Therefore, the court finds. And then immutable autistic traits of bottom-up, detail-oriented language were targeted as the reason to enter this order against me here. Now, I'm autistic. Of filing lengthy, complicated pleadings. Of filing pleadings on the eve of hearings or trial. And here the judge states that plaintiffs agreed that they have not been successful in these suits, but attribute their lack of success to the court system's inability to accommodate Mrs. De Petrano's disabilities. So we see the same ableist law school graduate stereotype alive, kicking and at play here with another judge, a circuit judge, Florida Circuit Judge Honorable Monica Brasington. And what you see, but there are many, many judges. They all do the same thing pretty much. And I mean, this is just, it's like when a bunch of lawyers who have offices in a city happen to go out for lunch, and then they meet at lunch and have lunch over a table, and they start talking together about how to litigate cases and how to win cases and this kind of thing. They're at some point discussing what to do when they have to encounter a pro se litigant. And then they're exchanging this boilerplate language, this ableist stereotype, that if you find out that that pro se litigant is a law school graduate, then what you want to do is you want to tell the judge the ableist law school graduate stereotype, because your case will go better for your client if you do that. And then the judges, as we can see, here's two examples. I have many, many more examples, real examples. Then they pick up that neurotypical code speak, that ableist stereotype, and trot down the ableist stereotype path of the law school graduate stereotype. Both of these judges, the Honorable James D. Whittemore, United States District Court Judge, and the Honorable Monica Brasington, Florida 8th Judicial Circuit of Florida Circuit Court Judge, they both were dismissive about my autistic disabilities and about my autistic need for accommodations. They seem to either not know or not be aware of what the Florida Board of Bar Examiners and the California Committee of Bar Examiners are doing, that they in fact give special accommodations to individuals with disabilities to take and pass bar exams and be certified for bar admission to the state bar. That means that law school graduates, in fact, some of them have disabilities. And people who pass bar exams, some of them, in fact, have disabilities. And even some licensed lawyers, bar members, in fact, have disabilities. So what we have is, let's go back to this definition of stereotype. A fixed or generalized mental picture of a group, law school graduates, who are a generalized mental picture of an entire group who is not disabled. It's an oversimplified opinion and a prejudiced judgment. It's a shortened way of thinking about people based on their group membership rather than individual. And from both of these judges, the Honorable James D. Whittemore and the Honorable Monica Brasington, one a federal district court judge, one a Florida 8th Judicial Circuit of Florida Circuit judge, I got the implicit or stated phrase, "You know better." Okay, I know better what? What do I know better not to do? Do I know better not to have immutable autistic traits that are beyond my control because I have a different autistic brain and central nervous system? Do I know better because law schools can cure autism or are giving applied behavioral analysis therapy? Well, let's take a look at this. I graduated from the University of San Francisco School of Law. And we're going to take a look here at their required curriculum, okay? In the first year of law school, you take civil procedure, contracts, criminal law, criminal procedure, legal writing, torts, and skills for future lawyers. In your second year, you take constitutional law 1 and 2, property 1 and 2, and upper division courses that have to be completed after the first year of law school. You have to take advanced legal analytics, evidence, legal drafting, legal ethics or professional responsibility, and upper level writing requirement. And that's here. Now, the curriculum, when I graduated law school, when I was enrolled in law school at the University of San Francisco School of Law, was essentially the same. Do we see anywhere in their court curriculum applied behavioral analysis for the autistic law students? No. Okay. What about the American Bar Association accreditation standards for law schools? This is an AI overview of American Bar Association accreditation standards for law schools. And it requires a curriculum that covers substantive and procedural law, legal analysis, research, communication, ethical responsibilities, and other professional skills. And this is a breakdown of the core curriculum requirements here. And this is what led to the University of San Francisco School of Law having to have the curriculum that it did. So nowhere in here, even in these other important considerations, do we see anything addressing, there is no ABA, American Bar Association, accreditation requirement that autistic law students receive a course in applied behavioral analysis for autism. And that can be found on a Google search that brings up the AI overview. And so by the process of elimination, looking at all of this, all of these circumstances in toto, the only conclusion that can be reached is that neurotypicals and lawyers and judges in all of our state and federal courts somehow think and reason in their neurotypical social expectations that somehow if an autistic person is a law school graduate, graduates from law school, or has passed a bar exam, or heaven forbid, becomes a licensed lawyer, that means their autism has been cured. It doesn't exist because of the ableism stereotype that law school graduate, bar exam passer, licensed bar member, licensed lawyer means that the person is not disabled. In order to be autistic and not disabled, basically, because you're born autistic, you die autistic, you are autistic for your entire life. And autism can't be cured. So their reasoning, their inferences, their ableism stereotype that they're applying to autistic people when they are forced into courts or dragged into courts is that a law school graduation cures autism and that you know better, because the inference can be made that the American Bar Association accreditation standards for law schools and that the law school curriculum must have, that's a neurotypical assumption, must have included applied behavioral analysis for the autistic law students, that they would have had to take a course in that. Well, that's not so. That doesn't exist. It's commonly known. It can be taken judicial notice of. It's so commonly known by any court or any judge. And so I put in the query into a Google search, law school does not cure autism. And here's what it told me. Based on the provided search results, here's my query, law school does not cure autism. Law school does not cure autism. Autism is a lifelong developmental condition and affects how individuals interact, communicate, learn, and behave. There is no cure for autism. Law school does not cure autism. I can make it bigger. Law school does not cure autism. And that's my video for today on the topic of law school does not cure autism. And so, in closing, this is the pillow that Mayo Clinic gave me right before my breast cancer surgery, and I think it's very appropriate as a conclusion to this video. Don't give up. If you like my videos, please hit the subscribe button and ring the bell, and you'll be notified of my future videos. And thank you for watching.